Okay, awesome. All right. Okay. Hello, everybody. My name is Chidera Ekwem, and I'm from Houston, Texas. And I currently attend Thurgood Marshall School of Law, and I will be a 2L coming up this fall semester. Next slide, please. I first found my interest in environmental law through a brief section in my property class that covered takings, the Clean Water Act, and the Clean Air Act. Then I found more interest through a mentorship program with Enbridge, which is an energy company here in Houston, where I'm from. My mentor from the program is an attorney who works as an in-house counsel for Enbridge, and also serves as the Federal Energy Regulation Commission Chief Compliance Officer for Enbridge. After hearing my mentor's experience as a FERC attorney, I was even more interested in energy law, and I've participated in energy negotiation competitions, and through this program, I was able to further my journey into a career in environmental law. I'm truly grateful for the opportunity to be a part of this fellowship. I'm truly grateful for Samantha and Nicole for guiding me in my work, for my peers for sharing their insight, and for being able to be tasked with researching environmental laws in 2 states, those states being Texas and Arkansas. Texas was special to me because that's where I've been my entire life. And as a Texan, I know that Texas has crazy weather like yearly hurricanes, extreme heat, and every once in a while there's a random ice storm. But what I really wanted to focus on with this project was something that was more tailored to my experiences with flooding in Houston. Taking that into account and looking through secondary sources to begin my research, I noticed that Texas and Arkansas have a big agricultural economic presence and are 2 states that are faced with intense climates such as flash flooding, drought, hurricanes, and tornadoes. And this means that landowners and farm owners must adapt to these environmental pressures. Something else that I noticed was that Texas and Arkansas have institutional support for environmental quality and conservation that stems from federal laws. Next slide, please. When I talk about ecological resilience, I'm referring to the ability of communities and ecosystems to withstand and recover from extreme emotional disturbances. This is important because Texas and Arkansas experience more infrequent weather events every year, putting landowners and farmers at risk. The purpose of my research was to assess state environmental laws and their interactions with federal laws, state environmental laws and their interactions with federal laws to determine how they support or hinder resilience. Next slide, please. Ecological resilience is important because it prevents ecosystems from collapsing, it protects infrastructures and agriculture, and it enhances recovery after a disaster. On the other hand, there are also long-term effects of weak ecological resilience and as a lack of regulations and poor oversight. These long-term effects can be anywhere from flood damage to landowners, crop failure from wastewater discharge and drought, and economic instability in rural areas. While preparing, next slide, please. While preparing my research, I came up with a few legal questions for each state. For Texas, I wanted to see how Texas complies with federal water quality laws. And then I wanted to see how Texas laws provide, if Texas laws provide insurance protections for land and farm owners faced with damages from adverse weather effects. And lastly, I wanted to see if Texas laws either hinder or promote resilience by protecting or impeding the property rights of landowners. In Arkansas, I took a slightly different approach. By looking at whether Arkansas has laws that provide relief to landowners, I then looked to see if Arkansas laws promote resilience among farmers through drought planning and water laws. And lastly, I looked at ways that institutional oversight supports landowners in Arkansas. During my research, I discovered that Texas actually, next slide, please. During my research, I noticed that Texas has EPA-approved implementations under the State Water Quality Control Act, which is a response to the Federal Clean Water Act. Texas also has the Texas Commission on Environmental Quality, also known as TSEC, which oversees the Texas Pollutant Discharge Elimination System, or TIP-DES, which is Texas's version of the National Pollutant Discharge Elimination System, or NIPDES. This federal and state cooperation ensures pollution control is tailored to local needs, all while preserving nationwide standards. When it comes to public policy, Texas has laws that restrict landowners and the government. Certain laws can prevent landowners from diverting or impounding surface water in ways that cause damages to others. And other laws, like Article 1, Section 17 of the Texas Constitution, prevent government takings by acting in ways that deprive landowners of their property without just compensation. As far as insurance coverage and relief to cover from extreme weather effects, Texas has established a floodplain management through the Texas Water Code, allowing governments to implement floodplain management as a requirement of the National Flood Insurance Program. The Texas Insurance Code orders insurers to disclose any exclusions in flood damage coverage to ensure transparency among property owners, and other laws that govern water management and recovery are also vital for building ecological resilience. But sometimes they can have unfavorable consequences in terms of land use and government takings, and this can be seen in the following cases. Next slide, please. In Commons v. the City of Houston and in San Jacinto River Authority versus Ackley, which spanned from the original case, which was Ackley versus San Jacinto River Authority. In Commons, we basically see a floodplain ordinance in the City of Houston as a response to Hurricane Harvey, one of the worst hurricanes to impact the City of Houston, which caused catastrophic flooding and impact over 300,000 structures. In response to the floodplain ordinance, a developer actually sued the City of Houston for inverse condemnation because they were actually unable to utilize property for housing, and they argued that the city's acts could be considered a government taking. The city argued that its actions were a valid excuse of policing power, and the case ultimately ended up going to the Texas Supreme Court. And the Texas Supreme Court held that compliance did not preclude landowner compensation. In the SJRA case, a group of landowners sued the San Jacinto River Authority because the water was released from Lake Conroe during Hurricane Harvey and caused a lot of flood damage. The landowners claimed that the river authority's actions may be a government taking, but ultimately the appellate court found that the landowners could not show causation to support their takings claims. These cases are actually important because they show us two instances where laws that are put in place to help prevent or protect from adverse weather can end up hurting or affecting landowners, especially those in flood-prone areas. After doing my research on Texas, I saw how the legal framework needed to reconcile with expectations of landowners while also maintaining adequate water quality and protecting the public from effects of adverse weather. Next, please. My research on Arkansas was centered around disasters and emergencies. It was centered around things like disasters and emergencies, more specifically on how Arkansas law authorizes the governor to coordinate emergency response efforts when faced with extreme climate. A statute in Arkansas allows the governor of Arkansas to actually suspend regulatory statutes that may delay emergency action. It allows the governor to utilize state resources, control movement within a disaster zone, and even commandeer private property with just compensation. The statute also establishes disaster response and hazard mitigation funds. Another statute appoints the Arkansas Natural Resource Commission to manage flood prevention and control. ANRC can be used. Sorry, my apologies. The ANRC can use engineering inventions to clean and reshape waterways. They can construct dams and reservoirs and build artificial barriers like levees and floodgates. When it comes to drought water and planning, Arkansas has regulatory responses to drought through the Arkansas Water Plan, which is administered by the ANRC. The water plan requires the implementation of a drought contingency network that includes state, regional, local, federal, and even private entities. This network provides public alerts, information dissemination, and water conservation efforts. And the water plan also stresses the need for steam gauging networks to monitor water flow to support evidence-based decision-making during droughts. As far as institutional oversight, the Arkansas Soil and Water Conservation Commission plays a pivotal role in overseeing these state water resources and shaping policy responses to drought and flooding. Not only does Arkansas's legal framework focus on agriculture and public infrastructure resilience, but it also focuses on creating programs targeted towards preparedness amongst landowners. These programs, like the Weatherization Assistance Program, seek to improve energy efficiency and enhance resilience of residential structures by retrofitting homes with energy efficient materials and technology. These technologies reduce vulnerability to extreme temperatures and outages that are caused by climate-induced weather extremes. Similar to Texas, I looked at case law in Arkansas. Next slide, please. And I found something interesting. I found an interesting case related to institutional oversight of water services. And that's the St. Francis River Regional Water District versus the city of Marmaduke. In St. Francis, a water district actually sought an injunction against the city of Marmaduke to prevent it from supplying water to a manufacturing facility located in the district's jurisdiction after it expanded its operation. The district argued that the statute gave it the right to provide water services to the plant, and the appellate court looked at this argument but decided that there was no exclusivity in services, that after looking at the city's long-term services to the plant, they ultimately decided to give the city the rights to supply water, even though a statute provided for the district to supply water. The reason why I chose this case, I know it might be interesting, but it actually highlights a complex interaction between two government entities, and it shows how judicial interpretations can actually have an effect on statutes established to promote ecological resilience. When it comes to Arkansas environmental law, Arkansas has an approach to ecological resilience that supports emergency readiness, resource management, and legal oversight. Next, I think, next slide, please. Sorry.
I think that's the last slide I have.
That's the last slide you have? I think I might have given you an incomplete slide. But but is it okay if I continue?
Of course.
Okay, sorry. I was just gonna wrap it up. This is like kind of just like the wrap up portion. Everything in my research actually helped me answer the legal questions that I presented for Texas and Arkansas. In Texas, the federal water quality standards are met through tip desk and are overseen by TSEC. The laws that align with federal programs promote landowners and farm owners' resilience, but sometimes those laws can be burdensome to landowners. In Arkansas, the legal framework establishes a plan for disaster relief through statutes that actually extend powers to the governor and work towards preventing or preparing for adverse weather events like floods and drought. And programs like the Weatherization Assistance Program show that a mix of laws and institutional oversight play a vital role in promoting ecological resilience amongst landowners and farm owners. As you've seen, Texas and Arkansas have laws that are dedicated to promoting resilience, from compliance and regulation in Texas to planning for disasters and executing emergency actions in Arkansas. Both states take different approaches to bolstering ecological resilience, but at the same time face similar issues in legal ambiguity, disputes in property right, and even limitations on enforcement. Overall, in order to further resilience efforts, Texas and Arkansas need to integrate long-term planning, interagency coordination, and strong land protection for landowners. That concludes my presentation. Thank you guys very much. Thank you everyone for your time. And at this time, I'd be happy to answer any questions.
Thank you, Chidera. go ahead and stop sharing, Sam. And yes, does anybody have a question for Chidera? We have some time for those. I'm going to ask you the same question I asked Anthony because I'm very curious. Did you come across anything that really surprised you in your research?
Yeah, I think the one thing that surprised me in my research were the cases that I mentioned for Texas and Arkansas, just because I know it kind of it was like kind of straight away from the main point of the project, but I think that it also highlights how certain laws can actually have that are supposed to help actually affect people in negative ways. And I just wanted to mention that to show that like these are ways that we can look at the laws that are being established by these states and how they're being interpreted at the judicial level, and use this as a way to make a change in those interpretations. In those.
Yeah. Thank you. Okay. One more opportunity for a question. Okay, nobody's chiming up, but thank you so much.